So, good evening, everyone, and good evening, Mr. Sarkar. And thank you for accepting our invitation to share your thoughts on a very, very very good topic of where we will be discussing about the geographical indication and how it who can register geographical indications and what are the process of registering it and why we need to have the geographical indication in place. So we have Mr. Devjyoti Sarkar from S Majumdar and Company, who is the advocate at S Majumdar and Company and has 12 years of post qualification experience in the field of intellectual property rights, and he handles the large trademark portfolio for various clients in diverse sectors such as engineering, healthcare, FMCG, food and beverages, clothing and footwear, and he also actively prosecutes the oppositions and cancellation actions before the trademark registry, and also advises on trademark and patent licensing and assignment related matters. He's also actively involved in enforcing IPR in passing off and also for the infringement actions before the courts, and also handles the domain name disputes before World Intellectual Property Organization (WIPO), and he also handles the protection of the trademark in foreign jurisdiction. In addition to this, he is also an active member of the copyright team and advises on all copyright related transactions, including licensing and assignment. And he's currently chairing the Indian Trademark Office Practices subcommittee of the International Trademark Association. And he is also a member of different professional bodies such as APA. So with this brief introduction, we, on behalf of Pirate, we welcome you, Mr. Sarkar, and now over to you, and we can have your thoughts on the geographical indication and how it can be registered. Over to you, Mr. Sarkar.
Thank you, Dr. Jindal, for a very warm welcome. I will definitely try my best to speak on the topic. So I'll just jump on to the presentation, and then once we are through with it, I'll be more than happy to take on questions, if any, from the participants. So thank you very much.
So before you start, Mr. Sarkar, if I can give a logistic announcement for all the participants whosoever have, they are attending this webinar, they can, in case they have any question, they can type their question in the question box, or they can even raise their hands. And at the end of the session, we will, have the question answer session where they can either directly ask their question or they can leave their question in the question box. Over to you.
Thank you so much. So today we are going to cover about what GIs are, what geographical indications are, and what is the criteria for registration of geographical indications. What are the key ingredients which constitute a GI? How do we protect it? What are the cases, or what are the reputed or the well-known famous cases concerning GI in India? And we are also going to talk about how it is different from trademarks. And at the end of it, I'm going to share some success stories where GI products have been able to capture the imagination of consumers, and how GIs actually help them to increase sales of their products. So with that, I would take you to the first slide, which is what are geographical indications basically. So geographical indications are a collective community right. It's not a monopolistic right of an individual, but it's a collective community right, and that is assigned to identify either an agricultural product, like an agricultural goods, a natural goods, or a manufactured goods, or any goods of handicraft or of industry, and includes foodstuff. So like you can see on your right, I've given some examples of GIs which are in the nature of agricultural goods, for example, Nagpur orange, natural goods, I don't have an example here, but that would be in the nature of, for example, honey, which naturally exists in nature. Then you have manufactured goods. For example, as you can see at the bottom of your screen, on the right-hand bottom of your screen, Mysore sandalwood oil. That is something which is manufactured. And you have the famous, the Zardozi or the Banaras Zardozi fabric and the handicrafts made from that, which is an example of a handicraft in industry. And finally, you have the food stuff. So which is again quite popular. For example, you have Tirupati Laddu and you have Bangla Rasgulla, which is a hotly debated GI. And then you have Joynagar and Moa. That's again another foodstuff. It's like a sweetmeat, and we'll talk about that in detail later. So these are the kinds of geographical indications which can be protected under the law in India. And now that we understand what are the kind of goods over which you can secure a geographical indication, we come to the most important aspect of it. The most important aspect of these kinds of products, be it agricultural, natural, manufactured, or handicrafts or foodstuff, is that they need to originate from or be manufactured in a territory of a country or a region or locality in that territory. So what is essential is that that specific product, be it a natural product or be it an agricultural product or a foodstuff or the kind, they must be only available or they must be only available for manufacture or production in a specific geographical area, be it a country or be it a specific location in a country. Now, why is that? I will come to that in the next definition. Is that that specific territory or that specific region or locality should have a certain quality, should impart a specific quality, reputation, or other characteristics to the goods. And such characteristic or that such reputation is essentially attributable to that geographical origin. So, for example, the example of Nagpur orange, it is the special characteristics of Nagpur and the adjoining areas in the state of Maharashtra, which has a specific climate, a specific soil, and other ambient requirements, for example, temperature and the like, or the fertility of the soil, which produces that specific variant of Nagpur orange. So, therefore, the specific reputation of the quality which the product has should be attributable to that specific geographical origin. And it is only then you can claim your product and an attendant geographical indication there too. So that is something which is quite essential. And the last limb, which is again a very important aspect, is that in case where such goods are manufactured goods, one of the activities of either the production or of processing or preparation of the goods concerned takes place in that specific territory, region, or locality. So an example of a manufactured goods like I've given here is of Mysore sandalwood oil. So as you know, Mysore is quite popular for your sandalwood. And there are large swaths of jungles where you have naturally growing sandalwood. And it is only from that location that when that sandalwood is actually processed and then converted into sandalwood oil, and that entire process of manufacturing sandalwood oil from sandalwood in Mysore must happen at that specific area. So a GI will not qualify, or a manufactured goods, a GI for a manufactured goods will not qualify as a GI if you take the goods from that specific location, but you do not manufacture those goods in that specific area or locality. So that is what geographical indications mean in a nutshell. And I will next come to what is the criteria of identifying these GI products. So let us say you satisfy the requirements which I just shared in the first slide. Is that you have a natural product or if you have a manufactured product. But what is the main essential criteria which the GI registry looks at before your application for a geographical indication can at all be accepted. And the first amongst that is reputation. Now, in fact, that the term reputation in respect of geographical indication or products which refer to geographical indications has been held or has been decided by the Honorable IPAB in the Agricultural and Processed Food Products Export Development Authority, which is APDA, versus the state of Madhya Pradesh and others. Now, this was a case where the application for Basmati was rejected or refused because APDA had tried to include geographical locations uh, in various parts of the country, much more than what could be allowed. And they had tried to claim that all those geographical locations in India have a connection with Basmati. And there the IPEB had gone on to say that Section 21E of the GI Act makes it absolutely crystal clear that the reputation as a standalone factor for recognition of a geographical indication under the Act, it is rightly contended by APDA that the basic foundation of GI protection is rooted in geography and reputation of the product associated with the cultivation area as an important and standalone factor. So you have to establish that the products over which you want to claim a GI protection has had a specific reputation in connection with that specific geographical area, and that specific geographical area has been known to have sustain or to have a sustainable climate, infrastructure, or manpower, or traditional knowledge to create and manufacture those products, which has resulted over time into building up of a reputation for such products in that area. So reputation is something which is absolutely essential. The next important aspect or the criteria is the nature of the applicant. So unlike, for example, a trademark, it is very essential as to who is making an application for protection of a geographical indication. So it cannot be an individual or it cannot be a normal body corporate. It has to be an association of person or producers or any organization or authority established by or under any law. So it could be a society, it could be a cooperative society, it could be a body corporate as well, uh, but which represents the interest of the producers of the concerned goods. So that is the most important aspect. So unlike, for example, when we look at the concept of trademarks, it is not the owner of the GI who will itself use the GI in respect of the products, but it is the actual producers of the goods, of the natural goods, or the manufactured goods, or the handicrafts, or the foodstuff, or the manufactured goods, whose interests are to be protected by an association of people who have come together for the purpose. So it is only such an applicant who can make an application for registration of a GI. I then come to the next slide. Now, these are the ingredients of the application. So the most important ingredients are that when you make an application, apart from, of course, representing your GI in the form of a logo or a device, I need to give a statement as to how the geographical indication serves to designate the goods as originating from the concerned territory of the country or region or locality in the country. And also, I'll have to specify that what are the specific qualities, reputation, and other characteristics which are due exclusively or essentially to the geographical environment with its inherent natural and human factors. So it could be a natural factor or it could be a human factor, for example, for handicrafts. And the production, processing, or preparation of which takes place in such territory, region, or locality. The example which I just gave about Mysore sandalwood oil. So the processing or the preparation of which has to take place in that specific territory, region, or locality. Thereafter, I'll just skip 4 because you of course have to apply for the GI in respect of a specific class of goods, and that is something which is similar to trademark. So you have the international classification, the NIS classification of goods, and that is simply followed by the GI registry as well. The next aspect is that you will have to indicate by way of a geographical map of the territory of the country or the region in which the goods are produced or originates, or the goods are being manufactured. So it has to be by way of a proper geographical map. So I'll give you practical examples in the subsequent slides. But these are the core ingredients of the application which you need to file with the GI registry. And and thereafter, you also need to give a statement containing the particulars of the producers, who are the most important stakeholders of a GI. It is the producers of the concerned goods who are proposed to be initially registered. So you have an association, and it's an incorporated association whose interest is to protect the rights of the producers of the goods over which we want to seek geographical indication, and you need to provide to the GI registry the names of all those producers. And it is not only the names of the producers or the nature of the applicant which will serve the purpose, but you have to give all this information by way of an affidavit. And in the affidavit, you have to claim, the applicant has to claim to represent how it is catering to the interest of the association of persons or producers or of the organization. So it has to be by way of a detailed affidavit, and a mere statement will not suffice. Thereafter, the applicant or the association will also have to specify on an affidavit the standard benchmark for the use of the GI or the industry standards as regards the production, exploitation, making or manufacture of the goods, having specific quality, reputation, or other characteristics of such goods that is essentially attributable to its geographical origin. So, for example, if I take the example of let's say a handicraft like Banaras Zardozi, which I mentioned in the first slide. So, I, as an association, when I file this affidavit, I will need to specify what are the specific standards amongst the industry or amongst the producers who manufacture such handicrafts. What are the technical standards which one must adhere to? For example, the kind of thread to be used, or what are the patterns to be used, what is the kind of textile to be used. So these have to be specified in very great and intricate details, and so that there is a standard benchmark which is set for the producers to follow. Thereafter, such an affidavit, while making that application, should also have particulars of the mechanism to ensure that the standard, quality, integrity, or the consistency of these benchmarks, which I just mentioned, they are maintained by the producers, makers or the manufacturers. So there also has to be a mechanism of control or a regulation by which the association or the applicant can verify and check whether these benchmarks which have been set by the producers are being met by others, as in the people who want to be producers of those specific GI products. We've already mentioned about the map. These are just technicalities. So you have to give certified copies of the map, and usually these maps are, you could take that from the Geological Society of India, and that has to be properly attested by that body so as to verify the exact location in which such GI products are to be made available. And in case there is any human skill involved, for example, the handicrafts, for example. So one has to also clarify and specify the particulars of the special human skill which is involved, or the uniqueness of the geographical environment or other inherent characteristics or factors, which apply to those specific goods. The other most important aspect, that is point number G, is that I also need to have an inspection structure by which I can regulate the use of the GI in respect of the goods for which the GI is registered in that definite territory, which is mentioned in the application. So I also need to have an inspection structure in place by which I can ensure that all the producers who are members of my association as authorized users or the producers, they meet the set standards or the benchmarks which are required to ensure the consistency of the quality of the GI goods which are being manufactured or which are being made available for sale to the public at large. Now, so we've understood what are the basic core the ingredients of an application, and what is required to be prepared, what is the data which is required to actually proceed for an application before the GI registry. Thereafter, I actually come to the procedure. So once you have made that application, once you file that statement, you have made that affidavit, you have filed your certified copy of your maps, and you've given the necessary declarations, how does the application proceed further? So quite unlike any other forms of intellectual property rights in India, once you have made an application and there are no deficiencies in your application, that is, you have complied with the filing requirements of a GI, a special consultative group of not more than 7 representatives is constituted by the registrar. Now, who are these members of this consultative group? So these members of this consultative group are actually experts or authorities who are well versed in various intricacies of GI law or in respect of the products in question or the geographical location in question. So these are experts from diverse areas of various disciplines who are consulted, who are constituted as a consultative group, and who are tasked to vet the application which has been made by the applicant. And it is their own personal domain knowledge and their expertise which comes very handy to assist the registrar in deciding whether a specific application meets the criteria of a geographical indication. The other most interesting aspect is that, again, unlike any other forms of IP, if you look at point number 4, the applicant is also invited to make a detailed presentation before this consultative group to explain the nature of its application. And also, this application is scrutinized by the consultative group, and very much pertinent and pointed questions are asked in respect of the statements made in the application. And this actually assists the consultative group in deciding whether to ask for further documents, more clarifications, or to suggest that the application does not meet the criteria of a geographical indication. So once a consultative group has been prepared, and once you have actually given your when you have presented your application before the group will actually make a recommendation. And that recommendation is actually sent to the registrar within 3 months from the date of constitution. And after that, the registrar considers the application on merits and on the basis of the observations or comments of the group, and the registrar will issue an examination report. Now, as you can see, that the examination report, as is evident, that is quite similar in the field of trademarks or copyrights or patents. There could be certain conditions or limitations or modifications which could be requested by the examiner. So such modifications could be on the goods, on the geographical indication per se, or the area or the geographical area over which you claim rights, or they could ask for any specific technical standards which are required, or if they feel that your inspection structure which you have proposed is not robust enough, and things like that. So that is the examination report in a nutshell. And then you will have 2 months. The applicant will have 2 months to file a reply to that examination report and comply. And he will also have the opportunity of a hearing. But if the applicant fails to appear for the hearing or file a reply to that office action, his application can be dismissed as abandoned. However, if as an applicant you meet the requirements set forth by the consultative group and the the examiner or basically the registrar here, your application is accepted and your application is published in a separate journal called the Geographical Indication Journal, which is published from time to time. And just like you have your trademarks, or just like you have patents, registration of a GI is subject to opposition by third parties, and third parties have a 4-month, 3+1, 4-month period to file any third-party oppositions, if any, and it is subject to that opposition proceedings that your GI application is accepted for grant. So this is the entire flowchart in a nutshell, which I think I've just discussed. Another interesting point is that unlike trademarks, the GI register has two parts, Part A and Part B. Part A consists of the particulars of the GI which has been registered, and Part B, most importantly, contains the names of the authorized users. So once a GI is registered, a GI can be permitted to be used by producers, and these producers need to register themselves as authorized users of the GI. Now, so details of those authorized users are also entered in Part B, and that will help consumers at large to know that if I am purchasing a specific GI product based on its quality, on its reputation, I know that it comes from an authorized user, an authorized producer of the GI. And I'm not going to go into much of detail of the flowchart because I think we have just spoken about it in detail in the previous 2 or 3 slides. But one important change in this flowchart is that, as you may well be aware, that because of the Tribunals Reforms Act for 2021, with effect from April 4, 2021, the IPAB is no longer functional. So in case your GI application is refused, the remedy would be to actually approach, was to approach the IPAB in appeal. But now that the forum to file an appeal has been changed to the High Court. So we will need to see how that pans out, because we haven't had any new cases since then where any refusals have been challenged before a High Court. So to the best of my knowledge, such appeals would lie before the Madras High Court, because they would have supervisory jurisdiction over the GI registry, which is based out of Chennai. And of course, also you could also file it before the IP division, before the Delhi High Court. So appeals from any refusals could be filed before the High Court. So that's the registration procedure in a nutshell. So these are some examples which I've given for the viewers, and so this is exactly how a deficiency notice looks like. So this is when you've just made an application, and even before it goes to the consultative group, there could be certain requirements which you have not met. So as you can see, a very detailed deficiency notice is issued by the registrar or by the examiner. So this is in fact a case where this application was actually refused, and an application for Girijan honey. So this application was refused for a different reason. It was refused because it was not a naturally subsisting product. So it was Girijan it's a trademark which has been adopted by this specific applicant, and they could not establish that it's a naturally existing product over which they're trying to claim a geographical indication. So therefore, there was a deficiency notice which was issued. Now, once such a deficiency notice is issued, as you can see, like I mentioned, after you reply to the deficiency notice, this is what a notice looks like when the registrar constitutes a consultative group for further processing the application. So as you can see here, that there's a date and time which is mentioned, and we have been specifically, the applicant is requested to come and present its case. And in fact, the applicant is given 20 minutes. The applicant is also asked to, provide a PowerPoint presentation where the representatives of the applicant need to be present, and they need to be able to answer the questions which are put forth by the consultative group. Now, coming to the next slide, As you can see, after a consultative group has reviewed your application, has heard you face to face when you presented your application, it can make certain recommendations before the application is is accepted by the examiner, or the examination report is issued by the examiner. So this is an example of the recommendation of the consultative group in respect of Joynagar Moa. So Joynagar Moa is a very popular sweetmeat in Bengal, which is available only during a very specific time, which is during the winter months. And it has jaggery and some special other elements in it. So as you can see here, there are certain objections. For example, if you see the first, second, third, fourth objection, they were not able to define the territorial location by way of a proper map, so as to demarcate the proper geographical location of the area in which that sweetmeat or that that food stuff is prepared. So they were actually called back and they said that no, you have to give it to us in very much more specific detail. And if you look at the fifth requirement, now the applicant herein did not specify who would be the authorized users of that GI. So while they were convinced that yes, there is special talent and there are special ingredients, a climate, the timing, and everything which is associated with this specific GI, the applicant had not, provided who are the actual authorized users of that product. So who would be the producers? So they were called upon to say that within 6 months you will have to uh, file, or you have to register all the authorized users. And you can also see that there was also a requirement of submitting a report to the GI registry as to what is the impact of this GI. As in, has this GI been able to ensure that the economic interest or the prosperity of the producers, which is the prime interest of a GI registration, has been met or not. So that's the report of the consultative group. And based on the report of the consultative group, you have the examination report, so which is nearly verbatim or identical with what the consultative group has agreed upon, as you can see here. So this is the examination report for, again, Joynagar Moa, that GI application. And in fact, the applicant is given a very short time. It's given just a week from the date of communication to comply, because these are very much formal in nature. They were not too extensive. And once that compliance was made by the applicant, I'll come to the next slide. The application is actually accepted. I think I just come to this slide first. So this is the acceptance notice. As you can see, Joynagar Moa is listed in serial number 6. So this is the acceptance notice where the application is accepted for publication in the GI journal. And unlike our trademarks, the GI journal consists of a very extensive description of the entire GI application, not in a nutshell, but in exact detail. So I've just given an example of a very recent GI. Now this is not Joynagar Moa, but this is in respect of Dalle Khursani, which is actually a chili which is made in parts of Sikkim and Darjeeling, which again falls under the state of West Bengal. So as you can see here that the journal publication contains in great detail not only the description of the product, but also a great description of even the proof of origin. So the historical records of the historical origin of the chili, the description of the chili, the geographical area in which it is made, what are the climatic conditions for planting, how it is to be planted. As you can see on your right hand side, nutrition management or nutrient management, when it's to be cultivated, because again it's a manufactured product, but then again it comes from nature. The kind of irrigation, the kind of soil that is required, what is specific to that area, and all such technical details, and why it is unique to that location and why it is not available, which cannot be grown in other parts of the country. Inspection body, which we just spoke about. Then you have the regulation. As you can see here, it even talks about the number of representatives and the designation who would ensure that the authorized users of the producers conform to the regulations of the GI. So such is the detail in which the GI application is published. And as you can see, this is the map. And The areas marked with red are the portions where this specific variety of chili is manufactured, which can be grown, produced rather from the soils. That is also part of the publication in the GI journal. And of course, once there are no oppositions or there are no objections received by any third parties, it results to a grant. So this is what the certificate of registration looks like. You have the GI number. It mentions the name of the GI, which is the Dalikursani here. The device, which is like the logo, which is to be used in respect of the products. So if tomorrow they were to export these products or sell them in other parts of the country, uh, it is this logo which will identify the product as being originating from the original or the authorized producers of this GI. And of course, one has to specify the goods here, and food stuff here would fall under class 30, and this is so therefore it mentions chili. And you can also look at the map on the right, and if you see that the map also is specifically described in that registration. So you not only get the indication, the product, but also the geographical location, which is the most important essential aspect of any GI registration. So that completes our understanding of from filing requirements, how the consultative group functions, what is the examination report like, and how it is based on the recommendations of the consultative group. And you need to file a response to that. Then it goes to the publication stage, and of course, we are not getting into the detail of oppositions, but if there is no opposition, it leads to a grant which is valid for 10 years and which again can be renewed for subsequent periods of 10 years for eternity, just like trademarks. So I'll just come to the next slide, and this deals with the difference between GI and a trademark, because I think there are very important aspects by which we can differentiate a geographical indication and a trademark. First of which is that geographical indications, they are a collective community right. A collective community right because it protects the rights of the authorized users or the producers of the goods at the ground level. So these are the people who are there in that specific geographical location, who, because of traditional knowledge, because of the special skills, because of the labor, because of the geographical location, have that special skill to produce such products. So it protects their rights. Whereas if you look at trademarks, it's a private monopoly right. It is the right of the owner of the trademark himself, which is protected under the law of trademarks. It does not cover any community rights. So it's private in nature, whereas geographical indications is for the collective community who are protected under the specific authority of that applicant or the association who takes care of the interest of those producers. Next, a GI, it identifies a product as originating in the territory of a country or a region, as we have spoken about, or any other characteristics of the product which is essentially attributable to that geographical area. And when you come to trademarks, there is no such thing, because all that the trademark does is that it identifies a single source or origin. As to where or who is the trader or the manufacturer from whom the products or the goods originate, it has primarily nothing to do with or reference to the origin, the locality, or even the country from where such products originate. And that is quite evident from even a bare look at the registration certificate which is issued in respect of GIs, which we just looked at, that even the map is a part of the certificate which is issued by the GI registry. And as you know, under the trademarks law, there is no similar provision to that effect. The other important aspect is that since it's a collective community right, where the rights of the producers are being protected uh, by this entity, uh, any right to a registered geographical indication cannot be assigned. It cannot be assigned. It cannot be transmitted. It cannot be licensed. It cannot be pledged or mortgaged, or cannot be any other subject of any other agreement. However, it is only the right of a registered authorized user which can devolve onto the successors. So if I have a special skill to manufacture a handicraft, and I am a registered or an authorized user of a GI, I can transmit such rights to my legal heirs. But the right to the geographical indication cannot change hands, cannot be assigned. The ownership of the GI will always remain with that specific body corporate of the association who is tasked to ensure that the interests of the producers are taken care of. And when you look at trademarks, a trademark is freely assignable, like a commodity. I mean, it wouldn't be appropriate to use the term commodity, but it can be assigned together with the goodwill in the business. So if you have used a trademark in commerce for 5 years, 10 years, and you have accumulated a lot of reputation and goodwill, now it's a valuable commodity, a valuable asset rather than a commodity. It's an incorporated valuable asset, and that can be freely assigned, just like you would sell, let's say, a immovable property or a movable property. So it can be assigned freely, and it can also be placed or mortgaged like property. So you can have a charge or a lien on your trademark, by virtue of which you can actually, if it's a valuable trademark, you can even accumulate capital, share capital, working capital by pledging your trademark to, let's say, a financial institution, which cannot be done in respect of geographical indications. Uh, the other requirement, other difference is that a geographical indication may be registered in respect of any or all the goods comprised in such class of goods as may be classified by the registrar. So, for example, we saw that the chili was covered in class 30, but in respect of a definite territory, which we've discussed in the past. And of course, there is no such requirement in respect of trademarks, because, of course, in trademarks, you can cover as many goods as you want in a specific class, but it has nothing to do with a geographical territory or a country. You do not have to specify what is the exact location over which you want to claim rights. The first point I think we have covered, because again, in GI it has to be an association as an applicant, whereas in a trademark it can be an individual or a body corporate who has rights over the trademark, and they want to commercially exploit it, which is not the case with the registered proprietor of a GI. The registered proprietor of a GI itself cannot manufacture or produce those goods. He's only tasked to ensure that the goods which are manufactured by the producers are not misappropriated by others, to protect their interests, and to assist them in commercially exploiting the attributes of that geographical indication as a community at large. Again, in respect of GI, like I mentioned, authorized users of GI must be recorded with the GI registry, but there is no such requirement in respect of trademark. So if I permitted someone as a licensee to use my trademark, I may or may not register his title with the trademarks office. However, of course, there is one difference, is that if I have a registered user, I would need to register him, as a registered user of my trademark. If you look at the difference insofar as infringement is concerned, so in respect of GI, a GI is only infringed when someone who is not an authorized user, who is not registered as an authorized user of the GI, applies that GI in respect of any of such goods which originate in a specific geographical area other than the true place of origin. So anybody who is not an authorized user, and if I use the geographical indication in respect of my product, whether or not that product originates from the geographical area or location, I would be infringing the GI. Whereas in respect of a trademark, as you know, if I'm using a trademark which is identical and I do not have the permission of the right holder or the registered proprietor, and I use something which is identical or deceptively similar, in relation to the goods which are covered under that trademark application, so as to have a false, association with the actual originator, I would be infringing that specific trademark. So these are the main differences between a GI and a trademark. I'll just pause here for a second. So here we come to enforcement, because I think we've learned about what a GI is. We have gone and seen what are the ingredients of an application. We've even gone and seen what are the differences between a GI and a trademark. Now, it would be interesting to even now look at what happens if someone tries to misuse a registered geographical indication. So what are the rights which I have when it comes to enforcement of a GI? So am I entitled to the remedy of an injunction? Am I entitled to the remedy of damages or accounts of profits? So in that respect, uh, there is an instance where a very popular and famous GI, which is champagne, I think which many of you would be aware. So champagne is a registered GI with the GI registry in respect of wine in class 33, which is produced in the Champagne of the Champagne, some people pronounce it in that fashion, region of France. And this GI is registered by this organization of this association called Committee Interprofessional du Vin de Champagne. So in short, CIVC. Now, in fact, the GI law also provides for certain additional protection to certain kinds of GI which have an international reputation, such as Scotch whiskey, and then you have champagne, and there are some other examples as well. So in for this case, CIVC not only had a registration, but CIVC also had an additional protection issued by the Government of India under Section 22 of the Act, which has provided additional protection to wines and spirits, which is a very lucrative industry in several countries, including India, and where the Government of India also earns a lot of revenue from. And therefore, it necessitates proper protection insofar as reputed GIs are concerned. And that is how even this specific GI has been granted additional protection. Now, in this specific case, what happened was CIVC found that another entity by the name of Chinar Agro-Food Products was found to be selling sparkling wine of different flavors, as you can see on your right, in certain parts of Delhi, Punjab, Jammu and Kashmir in India, using prominently the GI champagne, which CIVC had registered in India as a word. Now, upon coming up this specific product, CIVC wanted to enforce their GI under Section 22 of the GI Act. And what happened in this specific instance is that the court was pleased to actually grant an injunction uh, in favor of CIVC. And the court went on to explain that champagne is not only a popular GI, the use of the mark of the geographical indication champagne without being a registered user and an authorized user of this GI of CIVC and without their consent, especially in respect of sparkling wine manufactured from grapes which do not originate from the Champagne region of France, is a clear violation of the rights provided to CIVC under the GI Act. So as you can see here, the court actually went on to say that the act of the defendants are bound to cause damage to the wine growers in the Champagne region, winemaking cooperatives, wine brokers and agents, grape processing companies, dealers and wine merchants of champagne wines, and clearly amounts to passing off an infringement of the plaintiff's registered GI champagne. The use of the term champagne by the defendants on these products, which do not originate from the Champagne region, amounts to infringement of the plaintiff's registered GI within the meaning of Section 22(3) of the GI Act. The protection, I'm just reading out from the essential parts of the judgment, the operative part. Protection afforded to an infringement of a GI is absolute in terms of Section 67 of the Act. Absolute protection is afforded because any infringement would be presumed to cause damage to the goodwill and reputation of the producers in the Champagne region. So as you can see here, the court has emphasized on the goodwill and reputation of the producer. It is not the goodwill and reputation of CIVC, which is of concern to the court in respect of protection of GI, which is very different to what is protected in respect of trademarks. And the court again further went on to say that if I allow the defendant to continue to use the word champagne in respect of any non-alcoholic sparkling wine, it is going to dilute the distinctive character and the reputation of the well-known geographical indication champagne as a high-quality sparkling wine originating exclusively from that region of France. And this would ultimately lead to the registered GI champagne becoming generic in India. And so apart from the injunction, which was obviously granted, the defendants were actually directed to deliver up all the goods, including bottles, cartons, labels, wrappers, boxes, etc., that were seized by a local commissioner who was appointed at the interim stage and handed over to the defendants for actual destruction. So this is actually a good example where a GI has actually been enforced by our courts successfully. A very reputed GI, and this gives a lot of confidence to the owners of GI to not only register the GIs in India, but ensure that their rights are protected even by the honorable courts and by the executive authorities, giving them a platform to ensure that the products, these quality products reach out to the intended consumers, and they can freely know that these products are original and then they are not counterfeit. I will then come to another example. Now, this is just the opposite to which we just discussed. So, this was a case where the owner of a registered GI, this was quite a popular case, where the owner of a registered GI actually failed to enforce a geographical indication in India. And the crux of the matter is that, as you can see on your right, the Darjeeling logo GI is actually the first amongst the first and the second GIs which are registered in India, being 1 and 2. Now, what happened in this specific case is that the defendant in this case happened to be ITC Limited, which, as you know, is one of India's foremost private sector companies, over almost a century in business in India. They are FMCG major as well, and they are also into the hotel business. Now, they had they were operating, or they're still operating, a lounge in one of their hotels called ITC Shonar in Kolkata by the name of Darjeeling Lounge. So it was a lounge where one could go and sit and enjoy the hospitality services of this company running this hotel. Now, the Tea Board of India, who is the owner of the GI Darjeeling Tea, in respect of tea which falls under Class 30, issued a notice and then instituted a civil suit before the Honorable Calcutta High Court, asking for orders uh, for injunction against use of the mark Darjeeling Lounge in respect of hospitality services, claiming it to be an infringement of the registered GI Darjeeling word and Darjeeling logo here. So let us see what are the arguments which were taken by the plaintiff, which was T-Board. So T-Board argued that the use of the word Darjeeling by ITC infringes the registered geographical indication and certification trademark owned by the T-Board. So the T-Board also had a certification trademark. Now, certification trademarks are quite different from GIs, and we don't have the scope to discuss this in this webinar. Um, it also claimed that use of Darjeeling Lounge is an act of unfair competition and has the effect of causing confusion amongst the guests who are visiting the Darjeeling Lounge, and that such guests would be falsely led to believe that there is some association or nexus of Darjeeling Lounge with Darjeeling tea or the tea board. And tea board also claimed that Darjeeling is associated exclusively with Darjeeling tea, and the use of Darjeeling in respect of lounge services is detrimental to the distinctive character of Darjeeling GI held by the tea board, and it discredits the famed GI, which is Darjeeling tea. The tea board also claimed that use of a mark comprising Darjeeling, in this case Darjeeling Lounge, is dishonest, and it erodes and dilutes the GI and certification trademarks of the tea board. Also, that use of Darjeeling by ITC Limited has the effect of passing off its services as those linked to Darjeeling GI and certification trademarks, and that tea board has been successful in securing or restraining others from using the word Darjeeling in other countries. and that it should be allowed in the home state as well. Because T-Board has been using its certification trademark much before the 1999 Act, GI Act, which came into force in 2003, came into force in India by way of certification trademarks. So it claimed that, look, I have been successful in the past in other countries, and therefore I should succeed in India as well. Now let's see what was ITC's defense in respect of this lawsuit which was filed for enforcement of a GI. And ITC said that, look, the name Darjeeling Lounge was adopted in a bona fide manner to name a part of its hotel, and in line with the scheme of naming various parts of its hotel after the names of West Bengal's well-known geographical sites. For example, such as the Pala Banquet, which is a famous dynasty who were there in West Bengal several centuries ago, Bay of Bengal Lounge, and Sundarban Lounge. So they had basically named parts of the hotel and parts of some of the services, hospitality services, or some guest offerings, for paying tribute or homage to the previous dynasties in Bengal or geographical locations in Bengal, and it had nothing to do with the products from those areas. It also argued that registration of a GI is restricted to goods only under various provisions of the Act. So your registration of a GI is only limited to tea in respect of class 30. And therefore the argument that your rights under the GI can be extended to other goods and services. For example, Darjeeling Lounge here is a service under class 43 and not under class 3. So your rights cannot extend to that. And there was also an argument in respect of certification trademarks where ITC argued that even for certification trademarks, the rights are only restricted to the act of certification of goods only and cannot be equated to regular trademarks. And that section 69 of the Trademark Act specifically limits the scope of certification trademarks. ITC also took the plea that, look, T-Board, being a statutory body which is not involved in trading of tea, cannot claim passing off an unfair competition since the basic essentials of passing off an unfair competition are not satisfied. Darjeeling is first and foremost name for place and which is not synonymous with tea, though may be one of the important aspects of Darjeeling. T-Board is therefore not entitled to claim exclusivity over the word Darjeeling. And the monopoly ends at tea, which is very important here. So whatever monopoly the GI Darjeeling provides to the T-Board, that only extends to production of tea from that geographical location, which is Darjeeling, and not anything beyond and over that. And the last point number 18, I just skipped 17 because that was to do with limitation. The T-Board also argued that ITC argued that the T-Board's success in restraining others from using Darjeeling in other countries is restricted to tea and related products and not cross-category complaints. Like, for example, in this case, which was, so ITC was not selling any tea at the Darjeeling Lounge, but it was just a recreational, a lounge where people could sit in and just spend time or, order some other beverages. But the ITC was not using the mark Darjeeling Lounge in respect of selling tea. Now let us see what are the findings of the Calcutta High Court. So the Calcutta High Court at the interim stage and later on, the suit was actually decreed in favor of ITC and T-Board's plea for infringement of a GI was rejected. So let us see what did the court hold. So the court said that even at the interim stage, before the single judge and also on appeal before the division bench, injunctions were actually denied to T-Board considering that there was no likelihood of confusion or deceptions to the use of Darjeeling as a part of a name of a lounge with that of T-Board Darjeeling tea. The court further held that the word Darjeeling cannot be exclusively claimed by the plaintiff, which is T-Board, by virtue of its registration as a GI or as a certification trademark, and therefore the claim of passing off at this stage does not lie. T-Board actually went on to prefer a special petition, which is SLP, before the Supreme Court. The Supreme Court actually refused to go into the merits of the case and directed the matter to be disposed of with certain directions to the Honorable High Court, to the single judge. And in fact, T-Board also agreed not to discredit or discredit the submissions of ITC, and they actually agreed to forego the entire process of trial, and they were okay with arguing the matter on their merits uh, at the final stage. Now, so therefore, instead of going into the lengthy process of trial and examination of witnesses and documents, the parties went ahead and argued the matter on merits before the Honorable High Court, the single judge of the Honorable High Court. And let us see what was the finding of the Honorable Calcutta High Court. So, in February 2018, the Honorable Calcutta High Court was pleased to dismiss the suit. The court actually went on to reiterate the findings of the interlocutory court, which was the interim, the court hearing the interim injunction. Uh, and the court found that the plaintiff, that is T-Board's registered GI, are restricted to T, and the protection afforded by the same cannot extend to lounge services at ITC Shonan Hotel. The court further observed that the plaintiff had failed to establish a case of passing off, dilution, or unfair competition. The court specifically held that Darjeeling, being the name of a place, cannot function as a regular trademark. And though Darjeeling may be famous for tea, the plaintiff is not entitled to allege that Darjeeling cannot be used by any other trader for their own goods and services other than tea. So this tells us that your protection of GI is limited. Of course, it has a complete different connotation in respect of trademarks. So one cannot go on to enforce its GI like it would do in respect of a trademark, because the entire purpose of protection of a GI is wholly dissimilar to what is the ultimate aim behind the protection according under the GI Act. It is to protect ultimately the interests of the producers of the goods which are certified to be geographical indications. So it is not the right of a specific individual or a body corporate which the GI seeks to protect, which the T-board tried to do in this instant case. So I'm given to understand that right now an appeal has been filed from this decree before the Honorable Calcutta High Court, and that appeal by the T-board is pending adjudication. So we've learned about a case where CIBC was successful in enforcing the GI champagne in India, and now we have gone ahead and learned about another case where T-board was not successful because of specific reasons in enforcing its GI restricted to tea in respect of lounge services which fall under class 43 by ITC. Another interesting piece of, I mean, this was quite popular. This was all over in the media. I think you would have heard about this specific case. So the the state horticulture, association. This is West Bengal State, not horticulture. It was the State Food Processing and Horticulture Development Corporation Limited, which is a constituent body under the government of West Bengal, who went ahead and they registered the GI Bangla Rasgulla. So Rasgulla, as you know, is a very popular sweetmeat in this part of Bengal. Also in other parts of India, it's popular. For example, if you go to Delhi or if you go to Bombay, you would have Rasgulla, as it is called there, which is available. But the government of West Bengal, through this association, was able to secure a registration for a very specific, type of rasgulla or rasgulla, as we call it, which is available here. And that became a bone of contention between the state of Orissa and the state of West Bengal, because what happened was that an individual by the name of Ramesh Chandra Sahu, who happens to be from the state of Orissa, who filed an application for removal or cancellation of the GI on mostly the ground that the product or the manufactured product of the foodstuff here, which is rasgulla, cannot be monopolized or equated to Bengal, because it also has a history or origin in the state of Orissa. So that was the ground under which primarily the cancellation was lodged. Now, interestingly, what happened is that this gentleman was not able to, file its evidence in support of its cancellation within the due timeline. So he filed a cancellation, the government of West Bengal filed a reply, filed a counter statement detailing why the cancellation file should not be or not be taken on record. But Mr. Ramesh Chandra Sahu was not able to file his evidence in support of registration, in support of the claims which he made within the due timelines before the GI registry. And on account of this technicality, although it's a technicality, but it is what is the settled law, that his evidence could not be taken on record, and in fact, his application for cancellation had to be rejected as to have been abandoned. So, like I'll just read out from point number 5 here. As you can see, the applicant for rectification failed to file evidence within the mandatory timeline, which is 3 months. And Mr. Sahu did file the evidence, however, the same was after a substantial delay, as well as the fact that he was not able to substantially explain as to what is the sufficient cause for providing, explanations of the delay. And that is why that delay in filing that evidence became fatal, and the rectification was actually dismissed by the GI registry. I've also been given to understand that the gentleman has actually preferred now a review before the registrar of GI, and he is contesting the matter. And the reason I've spoken about this specific GI and the cancellation filed against it is that there was a lot of noise with the media, and a lot of people wrote a lot of articles and media articles where people tried to claim that Rasgulla is only in Bengal. But the fact of the matter remains is that the rights given to the state of West Bengal, specifically under that authority, the West Bengal State Food Processing and Horticulture Development Corporation Limited, is limited to a certain category or type of Rasgulla which is produced only in the state of Bengal. And it has nothing to do with the true origins of Rasgulla, which again this gentleman has questioned and debated upon. So that is the entire so-called controversy in a nutshell. Coming to the to the final stages of this presentation and this webinar. What are the importance of, why should I register a GI? So there are 4 broad points or broad grounds or considerations which I should we should discuss as to why a GI ought to be registered. And we have spoken about this in great detail. So primarily it is to protect the interests of producers of the goods. So a GI should be registered so as to ensure that the economic prosperity of the producers of such goods are taken care of, and it is not exploited by individuals or body corporates to the detriment of the others, or the other producers who all come from the same geographical area, who all have the same skill set because of those special historical backgrounds or the origins of the products. So it is to protect the interest of producers of these these GI goods. Why a GI should be registered. The other aspect is that it also helps securing a GI registration from the registry, also helps in promotion of the goods, which are protected as GIs for the export market. So when you have a product which is a geographical indication and which you may not have registered, something which is unique to your specific area, and you try and go to the export market, if you have a GI registration, it tells to the public or the world at large in such export market that look, this actually originates or comes from the actual source and are made by only authorized producers. So that attests, that itself, the indication itself attests to the quality of the product. So that is why one must register a GI. In fact, there have been several instances where, for example, tea or Darjeeling tea, which is quite popular and we just discussed about. So tea from parts of Sri Lanka, Nepal, and some of the neighboring countries were passed off in the West, in the UK or the US, as Darjeeling tea, without the use of any geographical indication. So if you simply write Darjeeling tea and the tea originates from, let's say, from Ceylon, which is Sri Lanka, or Nepal, and you believe that, whereas the actual product has originated not from Darjeeling in the state of West Bengal. You, one, are not buying the true product or the original product, and the original producers of Darjeeling tea in West Bengal and the tea board who are protecting their interests are not able to ensure that the original products get that kind of popularity in the export market, or the export market is deprived from the original products. So that is why registering a GI is also very essential, so that even in the export market, when consumers buy those products, they're able to look at whether the specific GI tag is imprinted on that product or in relation to the product, and they can only buy those specific products of their interest. And of course, the last point is that it will exclude, if you registered your GI, for example, champagne, since they registered their GI, they were able to prevent the misuse of the GI in India to serve, again, the end consumers and the producers from being deceived as to the true source or geographical origin of the products. So if I were to buy those products from that entity in Delhi who were making their products available in Jammu and Kashmir and the adjoining areas by making champagne, so-called champagne or sparkling wine from the grape which is produced in India, I would be deceived and I would believe that these are actually originating from France while they are not. So that is why one must register a GI, so that I'm able to stop the misuse of such geographical indications. And coming to the last slide, this is one of the success stories which I am aware of, and this happens to be Joynagar Moa. If you look at the left on the top, this is what a box of Joynagar Moa looks like. This is the sweetmeat, and this is basically nothing but popped rice. We call it what do you call it? I forget the name. I think I don't remember the Bengali name. So it is popped rice, and that is held together by fresh date palm and jaggery, which is only extracted during the winter months. And then you add some sugar, cashew nuts, and raisins to it. And this is only manufactured in a place called Joynagar, which is in the state of West Bengal. It's a specific area, and they were able to secure that Joynagar tag or Joynagar Moa tag, which is on the top right-hand corner in the year 2015. And as you can see that the registered, the authorized users or the producers of Joynagar Moa, they use that specific indication on that box. So you would know that yes, this is not just a Joynagar Moa which is manufactured in some nondescript location in any part of India, but it actually comes from those specific producers who are authorized, are permitted to manufacture it, and they do manufacture it in that specific location from where this date palm is extracted, and especially during a particular season during the winter months. Now, why is it a success story? It is a success story because since Joynagar Moa, the specific sweetmeat is available throughout the state of West Bengal, not only in Joynagar but in other areas in West Bengal. Initially, they did not have any mechanism to control the quality of those products. So the quality of these products were actually being diluted, and diluted in the sense that some other ingredients were being used. They were not being manufactured in Jayanagar. They were not being manufactured during the winter season. They were manufactured all throughout the year. So I, as a consumer, we were buying products which were fake, those which did not originate from that specific location. Now, having said that, they were not very successful in really promoting their products, because what they believed was that since they were so popular, they expected that people who are really connoisseurs, they would come to that specific location to buy and consume those products. Now that entire situation changed when COVID-19 struck. So when COVID-19 struck, obviously people stopped traveling to that specific location or that area to purchase those products from those local sweetmeat shops or the producers from that area. And that is when this association, which is Joynagar Moa Nirmankari Society, it's a society, they had to reach out. So what they did was they reached out to the government of West Bengal, and what they did was they got in a number of authorized users who are various bodies who are part of the state of West Bengal. So, for example, Bishwa Bangla, that's another initiative of the government of West Bengal, which actually promotes a lot of handicrafts and traditional products which are available in West Bengal. So they have tied up with those entities to promote their products and to make them available. So today these products are also available. So they have gone out of the comfort zone and they have even gone to large supermarkets and retail markets, like for example, Metro Cash and Carry, and this has resulted into huge and humongous sales which they never had when during the pre-pandemic stage, when they were only concentrated only in Joynagar. And in fact, this is actually a news article from the Hindu, where the society has claimed that these products are now shipped, I mean, post-pandemic really, or during the pandemic phase, you can say, they have now been shipped to not only different parts of India, but even to outside and foreign jurisdictions like Bahrain, Canada, and Hong Kong. And the volume of sales have increased manifold, especially now that people associate the specific GI only with the true and original manufacturers, and people seek to only purchase these GI mark products. So that's one of the success stories, and that's the entire webinar. I think we've captured from what a GI is. We've captured what you have to give when you're making an application, the process therein, and we've gone on to see what are the enforcements and why you should register a GI. We've seen what are the differences, and now we end with this success story. So thank you, everybody, and over to Dr. Vinita, and I look forward to any questions, if any, from the attendees.
Yeah, thank you, Mr. Sarkar. This was a wonderful presentation, and specifically the case studies that was very helpful to understand the complexity of the subject. And of course, the Darjeeling tea case, I think most of the people might be aware, but yes, now we can see the this Joyanagar Moa. So I think they call it as a moody. I am really not sure, but I heard in some part of Delhi, even Delhi NCR region, these people actually used to have specifically in winter. So I have seen that particular thing, but I was not aware this has been given as a GI tag. So thank you so much. So we have one question from one of the participant, Ms. Bhavna. So she's basically asking about like, is there any access? Is there any benefit sharing, excess benefit sharing component when you have a GI registered product? Because she is, I think, relating with the Biological Diversity Act, where we do have such components available, like benefit sharing agreement we sign. So, is there any such provision available in the GI also, GI Act also?
Not really. We don't have a similar provision in respect of Geographical Indications Act. There is no concept of benefit sharing under the GI Act, because the benefit of exploiting the GI for the products are completely in the hands of the ultimate producers, and who are the registered users or the authorized users. And they would simply pass on a certain percentage of the proceeds to the association to assist the association in managing the affairs of that association, to protect the GI, for the inspection, and for ensuring that the standards of the GI are being met. But there is no such a separate benefit sharing structure which is covered under the GI laws in India.
Right. So, if I can, ask one question. So we do, like in India, we call it as a geographical indication, but in some of the countries, it is taken as a appellation of origin. So how, I mean, what are the major difference between our GI Act and the appellation of origin when we go outside for the registration thing?
It's only a change in the name, because appellation of origin colloquially would mean that something which takes you to the origin of the product or the source of the product. And in our country, we have used the word geographical indication. There is no such major difference in the laws, because our laws are based on the TRIPS agreement, and it was a requirement. India being a member organization, it had certain obligations to protect geographical indications. So GI, as you know, it is called a sui generis law, and but in some other countries, for example, in France, you would call it the appellation of origin, but it's just a change in the nomenclature. So there is not, we don't have a major difference insofar as the, the law is concerned. It is pretty much, I would say, standard across the major developed and developing nations.
Okay. So I don't see any other question from the participants. So if anyone has any question, they can raise your hand, and you can
Dr.
directly
Vinita,
ask.
can I ask a question?
Yes, please.
Yeah. Mr. Sarkar, thank you for the comprehensive presentation. I just had a couple of questions. One is that since the applicant in a GI is not an individual but a group of individuals or a community, is there any minimum number of individuals that the community or the association is supposed to have to apply?
No, see, the nature, no, there is no such minimum requirement. What you need to have as an association is, for example, it could be a society. Now, the society could certainly have members. So that is not governed under the GI Act. It can be, you can simply have the minimum requirements as per the appropriate law. So, for example, if you look at the Societies Act, so whatever is the minimum number of people you need to have to incorporate a society. For example, there would be certain trustees and there would be members of the society. So that is what the requirement entails. There is no such special requirement under the GI Act to have a specific number of members as such.
Yeah, because in the Indian villages, there are so many crafts and which are being run by probably single or 2 or 3 families, which never see the light of the day many a times until unless you go deep down there. So until unless there is a sizable number, for example, the tea board is a huge board and we have a huge area under cultivation and tea growers. So for the smaller, probably handicrafts and such ethnic origin objects, practices, it may be difficult. So I think a lot of awareness is required to go deep down and actually make them come up and apply for GI and actually make money out of it for their
Absolutely, yeah.
livelihoods.
Agreed. So one has to take the initiative. Now, you mentioned, let's say, for example, handicrafts. If it's a handicraft and it's a skill which certain families in a specific area in this country they have, so it would entail that these families they come together. If there are at least more than one in number, so if they can come together, and if once they come together, they form an association. The association can be in the form of any body corporate, like a society, for example, because it has a
Sure.
scientific or a larger purpose. And it is that association who would then propose that, look, for the betterment of this handicraft and for the, to ensure the perpetuity that, this trade or this skill set is passed on to the next generation, that we come together and we form this association and we will transfer that skill to people who come from this specific, area. And for that, we will have a geographical indication, which will only
Right.
indicate that, look, these handicrafts from, this territory, and it has these specific skill sets, human skill sets. So yes, it has to be a concerted effort, and for that, we need more, more people to become aware, and for also the state to perhaps have some mega fairs, and promote GIs and geographical indication and these success stories in those trade fairs. So I think that is the best platform to attract, not only consumer attention but also the attention of traders or manufacturers in this in this area.
True. I had another question. Post the getting the tag of a GI, when people are applying for authorization. So, for example, for the Darjeeling tea, if some groups are coming and want to get authorized, so is the procedure same as that when the application is made, or through a consultative committee of experts, or there are set criteria which are there when a GI is granted, and then they just have to adhere to those 1, 2, 3? right?
Yes, the second is correct. You don't have to go through the process which the applicant does. There is no consultative group requirement. So it will be the criteria which has to be fixed by the owner of the GI at the time of making the application. So long as you cater to that criteria, there is a specific form under the GI Act. So once you conform to those rules and you come from that specific area, you can show that yes, your tea garden, for example, is in that area, and you have the manpower of the necessary skill sets and the other technical requirements, which is mandated under the GI regulations. For example, the Darjeeling tea, you would have to be, taken on board as an authorized user.
Okay. Thank you. That's all from mine.
My pleasure.
One thing, Mr. Sarkar, so basically, these societies or the body corporates, they are generally not for profit or for profit thing. Like,
See, they are usually not for profit. They are not for profit because they are simply assisting their members to earn the best potential out of the GI on the basis of their own skill set. So it is not the skill sets or the technical expertise of the association of the body which is being transferred to the producers to assist them with it. It is rather the other way around. So it is just that there is an umbrella body which ensures that the rights of these authorized users are being protected, and it simply assists in ensuring that they get the best out of their skill sets, or if it's a manufactured product, of the manufacturing requirement, because they have been there for generations and centuries in that specific area, and they're able to take benefit of that. So it's a not-for-profit organization mostly. So it could be a Section 25 company, it could be a society. So these are the nature of the organization. As you can see, of course, they can take a fee from the producers for managing the affairs of the society, but it's like you would have, for example, like an educational organization. It's a not-for-profit company, but to run the entire association, for the benefit, you need to have certain funds. So, for example, like let's say you want to enforce your GI. So where else would you get the money from? So this association would need to collect funds from the producers, from the owners, because it's a not-for-profit organization. So it would use your resources to assist you. So therefore, it's a social, legislation. It's a community legislation and not a private right or a monopolistic right, like in the nature of trademarks.
So thank you so much, Mr. Sarkar, for taking out time. And that was a wonderful session. And I hope everybody must have received some information about the geographical indication, because this is generally, not taken as a, like we always discuss about the patent. So it is not very obvious to have a geographical indication in place. Generally, people don't discuss much about the geographical indication. Thank you so much.
Thank you so much, Dr. Vinita. Thank you, everybody. Bye.
Thank you, everyone.
Thank you.
Bye.
Thank you.
Thank you. Bye-bye.
Thank you.